First, I want to apologize for my voice. I've been fighting bronchitis and laryngitis the last couple of days, so if it fades, then it's going to fade all the way. And the other thing that I would like to mention is one thing that Jim brought up, that he's not dealing with absolutes. And that reminded me that there are really only two words that you need to know to be a good lawyer. Answer to every legal question is, it depends. And no absolutes at all. I feel very pleased that I chose the way that I decided after talking with Dr. Anwar to do my presentation tonight, because I thought of the Foreign Corrupt Practices Act, where we tried to legislate ethics into the international marketplace, and it seemed a very dry way to approach it. And the more we talked, it seemed that my recent experience with an Italian company and the cultural differences that we've run into in dealing with that Italian company might make a good case study. Not from an ethical standpoint, but really just from a cross-cultural standpoint. For the past couple of years, I've been working with some Italian companies in connection with their invention of this thin reinforced stone. And they have invented a process for reinforcing very thinly cut granite and marble in a way that makes this thin stone about 15 times stronger than another natural stone, much thicker. It is something that they anticipate will revolutionize the building industry, particularly the remodel industry as we've seen it. Well, the way I got involved was beginning the representation of a small construction company over in Oklahoma who had become acquainted with this Italian firm. And they wanted to acquire, the U.S. Oklahoma company wanted to acquire the U.S. license to make, use, and sell this product in the United States. And that was the start of the story. And for the past couple of years, I've been working with this, and really from our very first meeting in Italy, I've seen the cultural differences. Our U.S. mentality when we began negotiations is shortly after meeting someone, after the introductory phase, we want to begin business. Usually after an introductory meal, sometimes even during the meal, the business lunch, we start trying to negotiate the situation immediately. Well, that's completely contrary to the Italian mindset. And I was acquainted with a firm who has offices across the world, but they have the branch office that I was familiar with is in Boulder, Colorado. And they're in the business of training U.S. business people on the cultural differences of other nations and how to best deal with those other nations. And it's Moran, Stahl, and Boyer, a consulting firm. And I contacted them because I've been familiar with them through some contacts with other clients that I had. And they set up a short session for our team to go to Boulder and visit with them before we went to Italy. I'm going to refer to them as MS&B instead of Moran, Stahl, and Boyer. They pointed out that Italians are a very ancient people, but Italy is not a very ancient country. Italy came together as a country. Before that, it was just a series of city-states. But it came together as a country only during the time of our Civil War in the mid to late 1860s. Consequently, their national institutions are not as well developed or sophisticated as what we would anticipate. They've also gone through 2 world wars, and they also a socialist country. And in many respects, their government is much more intrusive than our government here in the United States in business and in financial dealings. They are very concerned, because Italy is a relatively poor country, they're very concerned and place severe restrictions on currency export and on transactions that affect the balance of payments. MS&B also stressed that the Italians are very interested in getting to know you before they begin business, and that they slowly work their way into business discussions over a period of several days. They also pointed out that the Italians were more interested in, or were very interested in form and structure. They like to make a production of even the smallest things. And they're very proud of their facilities, and rightly so. They have some beautiful structures. They have some magnificent plants. We toured 3 different plants the first time we were there, driving from one side of Italy near Venice and Pickens across to a town just north of Torino, what we know as Turin, at the base of the Swiss Alps. And they are also very proud of their automobiles. We went about 125 to 140 miles an hour along their expressways, and they're good drivers, but they're very frightening drivers. And they're justifiably proud of their cars, too. And then we walked through their production facilities and their processing plants. And all of this, we spent about 3 days before we ever really began any negotiations, even though we were already convinced that we wanted to acquire a license for their process. And we knew what their manufacturing facilities looked like. Our first trip was largely introductory. We met them, we discussed a wide range of topics. We were able to secure an option for a U.S. license to their patented process. And then the subsequent trips have always involved walkthroughs of their plants and long meals and lengthy preliminary discussions. They don't have much fast food in Italy. In fact, we didn't see any fast food franchise chains, no McDonald's, no Burger Kings, no Kentucky Fried Chicken. And our Italian host said it's because every Italian thinks that he can do particularly cooking better than anyone else, and that he will not follow a franchise recipe. He'll try to improve on that franchise recipe. And there have been a number of franchises, and there are some down in Rome, down in the central part of Italy, but in the northern part that we were in, we never saw any franchises. There have been some attempted, and they've all failed because of that pride in their cooking and their ability. But food's an important part of their life, and it's an important part of their business life. Relatively small breakfasts, 2 to 3 hour lunches, dinners that began around 9:30, 10 o'clock and last until well after midnight. And each meal usually devoted to a particular topic. They like to work one topic all the way through from beginning to end before they move on to the next point. And these characteristics carried over into our formal negotiations. They're very concerned with the form of the agreement, almost as much as with the substance in some instances. Unfortunately, none of our U.S. team spoke Italian. And to further complicate matters, we've got a Hong Kong bank involved in part of the deal, and we've got British Aerospace and the Saudi government involved in another part of the deal. Fortunately, the Italian inventor, who's the managing director of the Italian company, speaks and reads English very well, and all the negotiations have been in English so far. There's also a 7-hour time difference between here and And that has worked very well for us because we generally work during the day. We revise the documents. Then we go to dinner. We make a couple of other revisions during dinner. And then I fax those changed documents back to my secretary. She runs through the changes on our computer and faxes them back while we're asleep in Italy so that they're ready to go the next morning when we begin. One thing that the Italians have been fascinated with is the ability to redline the documents, to underline the changes from one draft in the document to the next, so that you don't have to reread the whole document, but they still reread the whole document. During my negotiations with the Italians, we really engaged in all three categories of international business: trade, licensing of intellectual property, and investment. To the businessman, these broad categories, these three broad categories, describe three important methods for entering a particular market. To a lawyer, they also represent a different set of problems, because the level of foreign penetration by the client into a particular market will depend and determine the amount of entanglement in that country. For instance, the first category, trade, where you're just buying and selling, importing, exporting the goods, usually represents the least entanglement. And this is the least political, economic, and legal risk, particularly if the exporting firm doesn't solicit business in the foreign country or maintain sales agents or inventories in that foreign country. We became involved with the Italians in the trade aspect of international business when our client bid their product for the new Denver International Airport as the flooring for it. The Italians agreed to provide about $7 million worth of their product. My client agreed to install it at the airport, and that's currently ongoing, anticipated to be finished sometime in early 1994. Buying and selling the product has also involved accommodating the U.S. practices in business to their habit or their cultural practice of taking the month of August as holiday. And all of their factories shut down during August. They actually shut down the last week of July, all of August, and then they're ramping back up the first week of September. Well, in the U.S., of course, we stagger vacations, so our businesses continue all the time. Construction on the Denver airport did not terminate during the month of August and September. And so we had to convince the Italians to build up enough product in advance so that without too many hitches, we could continue installing during August and September. But we've also learned that August is a good month for negotiations. We have their management available to us during August for extended periods without interruption, and it's been very successful. We've also engaged in the second aspect of international business, which is international licensing of their intellectual property, their patents. Initially, we wanted to obtain the rights and did obtain the option to acquire the rights for their product only in the U.S. And then at the beginning of this year, we began, because of the possibility of NAFTA, to negotiate for, and this summer we acquired the rights for Canada and Mexico. We're now negotiating for the rest of the Western Hemisphere rights, and each stage has required the use of patent attorneys in each of these host countries that we're going to be working with, and working with the Italian patent attorneys. And each stage, of course, has become increasingly expensive and time-consuming. By its nature, licensing requires the licensor, the company who has the right to license its product, to become more involved in the business of the foreign country into which it's licensing. In this instance, the Italians are the licensors to the U.S. company, and then the U.S. company will sub-license this product and this process throughout the Western Hemisphere. With that comes greater legal entanglements than in the case of simply importing and exporting products. But the process also has more ties to the foreign country. You have to know more about their law. You have to know more about whether you are making an investment that can be appropriated by their government. And therefore it has more risk, both political and financial risk. For instance, our transaction has been complicated because of the current political and financial chaos that exists in Italy. And it's translated into a near financial collapse of the Italian financial structures. Our Italian company has come close to losing their working capital line when their parent company began a reorganization. And they began the reorganization to sell one of their other subsidiaries. But because of that, the Italian company has been struggling financially ever since. Because of this, we won't pay for the licenses because we don't want to pay money into Italy, see this company become involved in an Italian bankruptcy. If indeed they do lose their working capital within the 1-year period, which under Italian law, transactions can be set aside. What it comes down to is that the Italian company needs more working capital. And this brings us into the third category of international business, which is investment, which is the final level, and it's the most involved of all the international business. The acquisition of ownership and the active participation in an ongoing business is the most complicated and bears the highest degree of risk, obviously, of any of the other forms of international business. But this is what the Italian company needs. Consequently, we began to work with our New York investment bankers and with the Hong Kong Bank Group to raise money for the Italian company so that the risk of bankruptcy is not there, and so that we can safely acquire the licenses from them. The concept that we're working with is to create a British Virgin Islands company with an Irish subsidiary for tax purposes in the European community, and bring into that British Virgin Islands company all of the patents so that it becomes a patent holding company. It will then grant licenses worldwide, including licenses here in the United States. But it'll also bring in all the other proposed licenses, and that's where we've become more involved with other parts of the world. There is a proposed license in Saudi Arabia involving British Aerospace as the licensee, in which they're going to build a plant that will service the Middle East as their area. That has brought with it the unique problems under Arabian law. The Islamic religious leaders are the final arbiters of law in the Middle East. And in Pakistan in 1992, there was an Islamic court, religious court, that determined that paying interest in any shape, form, or fashion constitutes usury and therefore is forbidden. Well, needless to say, it has the financial community scrambling to try to cover the existing loans that they have, has the Pakistani government scrambling to try to get their World Bank commitments to continued funding. And the way that it's affected our transaction is that we're waiting to see whether the Pakistani decision will be adopted by the Saudi Arabian religious court, and if so, whether they will hold, as they have in the past, that royalty constitutes a form of interest and therefore is prohibited because it would prohibit then the payment of royalties in connection with the licensing of this. And the uncertainty of the validity of the British aerospace license for Saudi Arabia, because it's so important from a prospective revenue standpoint, has brought the public offering to a standstill. And it looks like because the institutional investors were very interested in the revenues from the Saudi Arabian company coming into the patent holding company. It's likely, it looks now, that it's going to be restructured so that there's a direct investment by the patent holding company along with British Aerospace, where they'll each own 50% or 25% of the company. And the Saudi Arabian government will own 50% of the company. And British Aerospace will guarantee the patent holding company a return on their equity equal to what they would have received as royalties. And the royalties simply will be done away with. So you can see that this has been a good case study for international law and the way the different cultures and the legal aspects of the different cultures impact the three major categories of international business: the trade, the transfer, and of intellectual property and investment. We hope to have a resolution of the loose ends of the project very soon, and we anticipate that we'll have the U.S. plant commencement of construction in 1994. That really is the extent of my exposure to international dealings, but it's been fascinating. Do y'all have any questions? Yeah,
I have a question with respect to intellectual property. How difficult is it to protect in Europe versus the United States?
Europe is very easy. What they do in Europe is they file a patent. For instance, the Italians file a patent application in Italy. It is immediately granted, and they have 1 year protection. And during that 1 year, they find out whether there's any patent infringement situation. Once they file it there, they are filed on all the European community automatically. So they have protection there. Then they file in Geneva for what's known as a worldwide patent application. And the countries, there are about 80 countries that are members of a treaty that they get initial protection in all of those countries by filing in Geneva. The United States, Canada, Mexico are not one of those countries. And so consequently, they have to make separate applications in the U.S., Canada, and Mexico and pursue those patent applications, which are in the U.S. are very rigorous. And Canada pretty much, and Mexico pretty much follows the lead of what the U.S. Patent and Trademark Office does. Thank you.
Before we close today's meetings, I'd like to take care of a few items of business. First of all, I'd like to introduce Mary Linderman with SPS. She had an announcement.
I would just like to recommend that anybody that is entering the export market, there's an excellent series at the Dallas World Trade Center that runs in the fall and the spring. I just completed the fall series of the export certification program. And for a person, they can go in on a Thursday morning, and the program's over at 12. You can meet with the counselors at the International Trade Resource Center, and they do counseling free of charge. It's an excellent way to network and to pick up some good information on 6 topics that are related to exporting. They will have freight forwarding. They will have finance, letter of credit. They do some cultural programming and different topics like that. So it's something that's accessible to us, and I have information on it if you know of anybody that would be interested in attending these programs.
I have a couple announcements myself. First of all, Syed Anwar is with the the international program at West Texas A&M as far as business, and they offer a concentration in the international business with a general business degree. And there's a little brochure on that. If you have any kids, relatives, or yourself that might be interested in the program. Also, there's a group called Independent Scholars that will be having a program in the same room on the 12th of December. It's going to be about the Texas state capitol, its history and restoration. And we also have a flyer back there for that. Does anyone else have any other announcements? Okay.
When is the next meeting?
The next meeting will be in January. We have not set the date. As I mentioned earlier, Paul Scanlon will be our speaker, and we're looking at a date in late January or early February, and we'll mail out reminders when we determine the exact date of that meeting. And again, I'd like to thank Dr. Jim Owens and E.T. Manning for speaking today. It's a pleasure having you.
Thank you.